end it on a high. We've got a session looking at the in-house perspective on post-pandemic arbitration, and I'll hand over to the moderator. Thank you.
Hello, everyone. I'm Michael Dorowski, International Arbitration Partner at McDermott, Will & Emery. I'm very pleased to be joined today by a number of client representatives. We have, to my left, Eva Kucic, who is Head of Legal at Spectra, Catherine Odeji, who is Head of Legal and Governance at EDF Man Capital, George Fisher, Disputes Counsel at SSE, and Ryan Thorne, General Counsel at Stonebridge. And I'll ask them to introduce themselves in a moment. But the purpose of today's session is to talk about the client perspective on key issues facing companies in arbitration. It would be interesting to get your views and insights on some of the topics we were discussing earlier today, because however much most of us here love arbitrating and arguing for its own sake, ultimately we do it all for you, the clients. So before launching in, could you perhaps introduce yourselves and tell us a bit more about yourselves, your organizations, and how you come across arbitration in your daily working lives or in previous lives?
Shall I start? Yeah. Spectra, I'm head of legal in Spectra, Singapore. Spectra is in event management and venue management. So you can imagine COVID, it wasn't a very good time for us. It manages more than 150 venues all over the world, including Singapore. Well, we do, as a company, have a position about the arbitration which changed during COVID time, and one reason was the cost. We couldn't afford going into any disputes using arbitration. We have either parked it or we are just waiting for a better time to resurrect, or we hope that we don't need to resurrect any disputes and finalize them through commercial deals. So that's the current situation.
Catherine?
I work for EDF Capital Markets. We're a financial services brokerage firm. With respect to the scope of our business, it's primarily exchange-traded products, which is largely fulfilled by electronic trading. But of course, we're members of the London Metal Exchange, which also still has its open outcry business. With respect to how we face or use arbitration in our general day-to-day business, generally, including previous employment, arbitration would usually feature in general commercial transactions. So it might come across in transactions that are not exchange-traded transactions, so general commercial items where they're more over-the-counter products, or transactions that are not heavily regulated. And with that distinction, we've got clear rules, clear regulatory provisions that govern our business generally. The exchange-traded universe is largely governed by the exchange rules and the applicable regulations. And so dispute resolution in that space is fairly certain with respect to the tools that you would use to arrive at a conclusion. As to how that featured or how we were affected by COVID and the business disruption, for want of a better description, not very much in terms of the exchange-traded universe because of the heavy IT infrastructure reliance. There were some other items with respect to collections where you have clients that are not domiciled in locations in Europe, where they might have been affected by more manual processes, but generally limited disruption, really. Arbitration in itself is favourable because it's effective, it's quicker, there's a bit more certainty, but largely it's something that's valuable for the business. More on the exchange-traded side because, again, of the certainty of the rules. Outside of that scope, it's favourable because we've got clients across the globe.
Yeah. Good afternoon, everyone. Pleasure to be here and hear all the opinions this afternoon. So I work for SSE, and they have positioned themselves over the last 10 years or more driving towards net zero, and have invested quite a lot in large infrastructure projects to that end, including the project that I primarily work on, which is the Dogger Bank offshore wind farm, the largest in the world. Needless to say, it comes with the territory that the supply chain for the project is vast. Even I have lost track of the amount of different contracts that the project has entered into, and that is right around the world. And so I think that arbitration is key, because as tends to be the way with international infrastructure projects, it tends to be international arbitration, which is the preferred dispute resolution mechanism, largely because of international contracting parties, but also I think that the level of expertise that the parties can specifically bring into resolving their dispute, and also I think, as it has been said many times this afternoon, that the inherent flexibility of solutions which the parties can decide on in relation to quite complicated issues which come up.
Great, thanks very much. I'm Ryan Thorne here from Stonebridge. So I am the General Counsel of Stonebridge, an M&A lawyer by trade, which is a little bit scary with all these litigators in the room, I have to say. But having that sort of private equity background, we see arbitration in a couple of contexts. Obviously in M&A and valuation disputes, quite a bit. And have had fun debating with various people on topics like that. And obviously commercial supply chain has been a big thing. And I think it's probably the one that's been impacted most by the pandemic returning to question. So we certainly would see it. It is probably increasingly prevalent when we're negotiating certainly international contracts, even sometimes in the UK when we include arbitration clauses. But it has generally been something that I know our investment committee and our directors would consider, when we're doing a transaction, because we know that one in every X is going to screw up in some way. There'll be a joint venture that fails. There will be a put or call option that doesn't work in our favour in terms of valuation. So we certainly will consider that versus other old, traditional means. So yeah, but very interesting debate as to date, and happy to continue discussion.
Thank you. We'll leave a bit of time at the end for questions from the audience, so please do fire those in for our clients. You started alluding to some of the experiences you've had during the pandemic, but maybe if we could drill down into that a bit more. If I could ask, what sort of claims have you seen, if any, arising out of the pandemic, and how have you tended to deal with those? Have many of those ended up in sort of full-blown disputes, or have you sought to just try and deal with them, and why are the reasons? Why would those reasons be? So, talking around that, Ryan, maybe you could start us off.
Sure. I think two primary areas. The supply chain is we have a lot of investments in retail, so that's been significantly impacted, as I sort of mentioned earlier. I have seen. We were chatting before, John, but I've seen an actual sort of general acceptance amongst parties and counterparties that you do need to get through this. And while things have ended up being litigious at times, and sometimes people talk about arbitration, a lot of things have actually ended up settling. And there has been a understanding that you've got a whole bunch of financial and operational risks that are kind of impacted by the pandemic. But all the counterparties have this. So, I'm happy to hear what other people's thoughts are, but I haven't seen as much aggressive arbitration, as litigation, as I perhaps would have expected.
Yeah, I completely agree with that. Obviously in construction, we've had our fair share of these types of claims, like force majeure, and change in law, actually, in terms of claims about change in law in the UK, in terms of visiting staff and employees not being able to get into the UK and having to quarantine when they get there has led to claims as well. But by and large, to date, it's my experience that it's been very amicable, and there's been a sense that we are in this together. That the project is still very, very early stages, and there's no appetite on either side to get bogged down in disputes at this stage. And actually, quite often when you stop and take stock and look at where the parties are, there is normally a commercial and practical solution. For the construction lawyers in this room, there's been LD holidays and resequencing, all kinds of solutions which are there, which are far more appealing to the parties at the moment. Having said that, I do think there's a risk going forward, particularly for us on the employer side, that contractors are going to, and I have actually unfortunately seen this, contractors are beginning to lump in claims which aren't really pandemic related into a general, like, oh, it's COVID and that's an excuse. And I think for now we're taking comfort that it's quite hard for them to demonstrate that, and the threshold is there in the contract, and the challenge is on them. But I do see it building up, and that being a source of friction between us and contractors going forward.
Do you want to go, Catherine?
I think from our perspective, our business is quite different. So we're a broker, so we stand very firmly in between the client and the exchange with respect to how those transactions go and those relationships go. There are very clear rules and very clear ways of operating in that particular sphere. One incident that comes to mind in terms of how the pandemic could have resulted in something disastrous in terms of litigation boils down to what might be simplistically called a collection issue. You've got a margin call, you've got a client who's adversely affected by COVID because certain things haven't lined up in the way that they expected, and so payment can't be made as quickly as they wanted to. However, we're a middleman, so the world carries on regardless. And I think because the sector is heavily affected, positively or negatively, but in this instance I think positively, by IT infrastructure, it's very difficult to then win the argument that you've been adversely affected by COVID, and so you can't continue your transactions in the way that you would have without COVID. But ultimately, when it comes to the, in order to preserve relationships and continue to build out business from one client or even new clients, there is that sense that litigation may not be the best way to achieve things. And same with arbitration, as flexible as it might be. So there is that room, possibly, that wouldn't have existed without COVID, to allow for parties to come to a resolution. But with respect to the costs being incurred, the ball keeps rolling. So yes, arbitration is valuable in terms of its flexibility, its reduced costs in comparison to litigation. I think ultimately, with respect to our business, there's been no significant change in that particular respect, just because of the way that we transact. Now, if we're a broker that dealt more with physical transactions, engaged more in mergers and acquisitions or any other kind of general commercial transaction, then it would be a different story, I think.
Ava, how would you say the pandemic's affected you?
Well, in the business that Spectra is in, well, the problem was many clients would use pandemic force majeure even for not paying something they were supposed to pay in mid-2019. So, and also because the scene is so international, the problem has been still different interpretations of the contract, although we do have a law which rules it. As well, mentality of the different nations coming in and considering the contract as a law itself. Many nations we work with, they signed the contract for sake of it, not to follow it. And that was also one of the reasons we were looking for mediation rather than arbitration, because it was faster. As well, we've managed then to settle before certain clients went to bankruptcy, and we knew that they will because we were monitoring their financial status. Therefore, in about 6 months, we've managed to close most of them in such a way it wasn't, it was more like a win-win to cover losses rather than any kind of gains on either side. But that's the situation in between two parties where both parties lose. And pandemic has affected our clients who are promoters and they bring events, and us who are helping them to have those events.
Thank you. And do you see the pandemic having a long tail in its impact on the sort of things that you're dealing with and the claims that you might be seeing? George, I know you do a lot of, obviously you have a very busy practice and presumably a lot of disputes on all the time. How do you sort of manage those?
Yeah, I mean, I guess the answer to that very much depends on the direction that the pandemic takes. That we, as I mentioned earlier, our supply chain is right around the world, and one of the issues we're facing is that cases might come down in Europe and go up elsewhere, and that can be very difficult to manage. I mean, we actually have a couple of suppliers in Thailand where numbers have been extremely high over the past month or so, and vaccination rates haven't necessarily been where they are in Europe, and it's caused a lot of disruption. And so I think it depends on where the pandemic goes globally. If things begin to settle down, then hopefully things will improve. At the moment, I'd say that the project's doing well, contractors are managing it well, but as the work begins in earnest, if the pandemic continues at the levels it has been, I think it may well cause issues, and really the only solution is to maintain that flexibility that I mentioned before within the confines of the contract and protecting our rights. But I think everyone recognises that there has to be a degree of collaboration to get through this. The key thing is that the pandemic's been going for 2 years, which pretty much coincided with the beginning in earnest of the Dogger Bank project, and in reality, it is going. The stages A and B have closed, and work has begun, and hopefully stage C will close in the next few months. So that in itself shows that we can get through this through that flexibility. That it doesn't have to be the disruption, but to some extent, it also depends on quite a difficult future to predict.
And looking into your crystal ball, Ryan, do you see any sort of other pandemic-related or other sort of business interruption events or economic changes or such that might result in more disputes?
I mean, so M&A is still strong. I think it was echoed at the beginning of one of the first sessions, I think. We are probably predicting, depending on how retail sales go at Christmas, maybe a new round of administrations Q1 next year. So, but that can be an opportunity for people. It's hard to look ahead in these things. I think people have our staff, and probably everyone's staff, have adapted very well. Of course, there are COVID clauses in most contracts now. In terms of either the force majeure or you've just talked about how you can allocate risk. If further variants and further lockdowns occur, then that will disrupt things, no doubt. But I mean, there's still opportunities out there. So I think we haven't certainly, it might change, it might make a pricing difference, but it hasn't sort of stopped us hunting for good deals.
And Ava, do you have any sort of thoughts about where disputes might be coming from in the future? Any sort of particular events you think might result in disputes for your business?
We are currently evaluating something that it was discussed here, you can't pass down. So meaning if there is an event ongoing and then you have a super spreader in between the patrons whose fault that is. We are playing with that. Interestingly enough, we do have conversations with different insurers, how to manage that risk, and also sharing it with the promoter and as well with patron, with the person, which is the most difficult part because and less controllable as well comparing to other two. Again, it comes into the execution and evaluation of how risky it is, well, we can't predict into that level. Yeah.
Moving on to another topic that was covered earlier today, we had heard a very animated discussion about virtual hearings, which have been a topic I think everyone's got an opinion on. But how do you view virtual hearings from a client perspective? How do you welcome them? Catherine, maybe you could give us your thoughts.
I think it's a question of transition. I think it's something that we would have had to have faced sooner or later. The fortunate or unfortunate thing is the pandemic has forced us to face it rather quickly. So the fact that we are using it as a tool now is welcome, I think. There are still issues to be dealt with, not least because it's something we've had to pick up as an emergency measure that perhaps we hadn't had time to bed down. So the technical difficulties that we're describing, indeed experienced today, the question of finding out, what would be an appropriate environment to have the dispute resolution session and how that might affect costs. I think in one regard, it would be favourable because for a company that I work for, we have clients all over the world. So with respect to time differences and ease of connecting, virtual hearings are definitely welcome. But conversely, I think there are issues to think about. So for example, confidentiality, data protection, how do we address all these things? We all have different laws and different rules that govern these things conceptually in different jurisdictions. But I don't know that we have one hymn sheet that we're all singing from that would equally apply across the board. So I think it's welcome, but I think there's probably still some more work to be done to get to a place where we're all relatively comfortable with it.
George, I think when we were discussing this, you were quite a fan of virtual hearings. What are the sort of pros that you see and you like from your perspective?
Yeah, I mean, that's a caveated pro virtual hearings. I think the session earlier was really useful, and I agreed with a lot of it in terms of substantive merits hearing. I think will remain in person for a while yet, for exactly the reasons that were discussed: the ease of instructions to counsel, the coffee break meetings, the just sitting there in a room together, eyeballing the witness and the opposition. But I think that there probably are arguably more procedural hearings and smaller hearings than there are merits hearings, and for them, for me, it's a no-brainer that they should be virtual now. And I say that for a variety of reasons, not just cost, but it was mentioned earlier, and I think that there is a risk to write it off as being a bit trite. But for green considerations, that back when I was in private practice, we had a half-day procedural hearing in Paris. We went across from the UK. We had counsel coming up from the rest of Europe, and then we had counsel flying over from America and clients from Central America, and all gathering and flying to Paris for a half-day hearing was just, with hindsight, nonsense when it could be done online, and the technology exists to do that. I just don't think that going forward, companies can really justify that expense and carbon footprint. So I think that virtual hearings for procedural issues should be the standard going forward.
Ryan, do you have any sort of thoughts on what the pros and cons are from your perspective of virtual hearings?
So I think the cost point is an interesting one, and I think the panel raised earlier, while it obviously is more efficient generally, and I appreciate the carbon footprint, it was an interesting comment that maybe you end up having more hearings, maybe more issues come out, so you get longer periods of time. The other thing I think you're missing out on is that opportunity to have chats in the corridor, so to speak, with the other side, and to bring parties closer on a lot of issues that may even help resolve the dispute, or it may just take 10 things off the table, which sort of saves in the cost. So there's a bit of downside there. One interesting observation with the panel talking about earlier was that I sense that people missed that advocacy and the showmanship of doing it live, which honestly I don't think as clients not only don't we care about, it's actually quite annoying. boards like CEOs and my ICs and like, they just sort of turn off and they think lawyers being lawyers. So maybe that's a good thing to think about generally, although many of you may have grown up wanting to do that. But yeah, it's interesting to hear how, I guess, people as practitioners are missing out doing that. But honestly, from our point of view, I think it's, if it can be issues focused and narrowing it down, and procedural elements can be more, dare I say, automated or done virtually, that should hopefully give a better outcome.
And if I could just ask you as well, when we were talking about this topic, you mentioned that obviously you do a lot of M&A transactions, which have also gone virtual. Are there any sort of insights that you've got from doing that you'd want to bring, you want to sort of mention to the
I mean, there are certainly parallels. We've certainly had, I must have had this conversation 3 or 4 times with either investment banks or sponsors or other funds, that not being in a place together, we can have that traditional, like, law firm has one central meeting for the parties and 2 breakout rooms to send people away to go and think about things, and then forcefully have the opportunity to maybe meet up afterwards and talk about the issues. Losing that on an M&A perspective has meant that people get more aggressive and hostile over Zoom and Teams and everything else. There is probably the same element, I suspect, in terms of how people are, and I think it was reflected earlier in the comments, how people are portraying themselves on any litigious way, when you already have an aggressive starting point and an emotional starting point. So I think there are certainly some parallels that I know people in the M&A side miss that physical presence. Maybe there are ways to solve that in a virtual way. I don't know. I have other breakout rooms maybe, but it doesn't have quite have the same feel.
Ava, I think you had views on this topic as well.
Yeah, I think we all have somehow. I agree with the views here, and I want to add. I mean, it was also a topic today. Moving forward, hybrid, it might be a good solution, or maybe in a further future to have holograms walking around. That will probably bring a little bit more of that camera here, screen there, another screen here, and all of that technology, which is not following up, actually. It's not. What we as people can do in one room, that is still far behind. And I think it's interrupting a lot. As well, I find I can only talk about negotiations in that way, because we didn't do dispute resolutions in this way. Yes, we did the mediation. But that was more as a commercial kind of negotiation. The dynamic of the room, it's very important, and we just don't get it. And that was as well making the conversation longer. People are not listening to each other. It's just a complete mess. It's just not working. Therefore, I think in arbitration or any kind of procedure, having some kind of a split in preparatory work can be done virtually when you don't need that crucial moment of a human factor and interaction. And then when the deal needs to break, to meet up and work on it. Yeah. I would just want to add, the other part of the virtual world is there's no time zone anymore. I mean, I'm in London now. I wake up 1 o'clock in the morning because I have a meeting at 2, right? So that's also one of the reasons, to me, are negatives of the virtual world currently.
Yes. Yeah. I think everyone's got experiences there. I had a procedural hearing. I was directed to attend a procedural hearing at 10 o'clock on a Sunday night, which I don't think would have ever happened before the pandemic, and I'm sure other people have had similar things, because the arbitrators were in Hong Kong, London and New York, and that was the only time that they could make. So there's greater intrusion, I guess, into everyone's lives because of the virtual world. How do you view that from a client perspective? Do you like seeing what books your lawyers are reading or pretending to read? Or would you prefer things to go back to sort of the discipline of the 9 to 5, 6 working day where you can't do that?
Was it ever 9 to 5?
Certainly for clients, in my experience. But Catherine, what do you think?
I think ultimately we're going to be framed, or we're going to be led by, where our clients are. If you have a client base that's spread across the world, then inevitably lines will be crossed. If you're doing a transaction in Hong Kong or Singapore, there will be some late night phone calls. It might be 4 o'clock in the morning, it might be 8 o'clock in the morning. So it really depends. So I think the fact that the virtual universe, the way that it is now, accommodates that flexibility across different jurisdictions, I think is a positive. I think it's a negative that we are eroding boundaries with respect to our own working hours. But I think that's just something that's developed over our commercial culture rather than something that's been a result of the pandemic, really.
George, what do you think?
Well, I think I'm in a fairly advantageous position compared to the rest of the panel here, in that we tend to have dictated already that our disputes are seated in London, so we could probably quite happily have nice, leisurely sort of 9 a.m. procedural hearings quite happily. But no, it is an issue, and I think that one thing that we have to remember on the client side is that this is ultimately a process to serve us. And whilst there's never going to be an easy compromise when different parties spread around the world, ultimately there should normally be a solution where most parties are happy, and ultimately we are paying counsel and arbitrators to provide a service to us, so it should be the clients really dictating the terms of when hearings take place. I think quite often I've seen it work the other way around, which isn't necessarily how it should be.
My sort of take on, or one of the concerns I would assume that clients might have about virtual hearings is that there is a certain loss of control that you have, in that you might not be in the same room as your lawyers, and you can't sort of stop them in mid-flow if they're saying something wrong, or pass them a note to tell them something's wrong. You might have to communicate with them sort of through some sort of chat function or WhatsApp. And then, one of the things that you guys were talking about were concerns about cybersecurity. I think, Catherine, you just mentioned it. Do you worry about any of those things, the loss of control and communication with counsel?
Yes. I mean, I've been involved, or I was involved a long time ago in a mediation session that was the ultimate result of an extended litigious exercise. And the whole process took a day. Now, it sounds very simplistic, but I think it took a day because all the parties were in the same place. There were lots of prompting with respect to the conversations across the room. You could, read expressions, and so you could get lesions as to how you might take a particular point, etc., or what you might want to say to counsel. So whilst I'm in huge favour of virtual hearings, I think there's still something to be said for that face-to-face interaction, because one, it helps you to communicate, I think, more effectively with counsel, because things might change. There might be a particular point that certain parties believe very strongly on by email or in written word, but on a face-to-face environment, it might be different. You might perceive something different, and so that might lead or affect how you make certain decisions with respect to moving forward. So it's a difficult one. I think in terms of control, yes, it is obviously much easier to have people in the same place, to communicate effectively, because we are still social animals at the end of the day. But nonetheless, I think the future is definitely going to sit with virtual hearings, whether we like it or not.
Yeah, I mean, one thing I would add to that, actually, and it was an excellent point which came up earlier, which is try and get an order. It's not perfect, but an attempt to ensure equality of arms, I think is a great idea. And one thing that I've been a part of in the past is, yes, a virtual hearing, but where the parties are sitting in a room with their counsel. The counsel can go on mute and receive instructions, and so long as it's the same on the other side, I don't really see an issue with that, and that actually can be quite an effective sort of compromise.
Ava, I think you mentioned concerns about cybersecurity and virtual hearings to me.
Yeah, I mean, yes. It is because we were as well looking into the risks using WhatsApps, for example, and other instant messaging, which is free, and the exposure to data breach and confidentiality is fairly great. The other is it can happen as well. We looked into that, and it happened in some of our discussions with the client that unfortunately not all people are technically savvy enough. So you would see private messaging on somebody's WhatsApp in front of on your screen, right? Because they just don't know how to share it properly in a way, and this kind of stuff. So when we now look into upgrading the business altogether, we invested a lot in technology, which also includes encrypted in-house software for messaging and exchanging messages. And we as well, when we are looking for external help, and we are looking that particular company has a technology already in place, or at least is investing or investigating how to improve it, so that the data is kept, and as well there is less risk of breach of confidentiality.
Thank you. And if we could quickly move on to the last topic I wanted to cover with you today. In the first session today, we heard about M&A and company law claims in arbitration. I wanted to explore with you, as users of arbitration, not just in M&A transactions, but in other commercial agreements, how you now view arbitration as a preferred means of dispute resolution, how frequently you include arbitration agreements in your contracts. George, I meant Ryan, maybe starting with you, sort of doing M&A transactions on a daily basis.
Sure. So I think it's certainly growing. I would say, I don't know, maybe 1 every 3. It depends on the context. Certainly, we foresee a potential deadlock in the future, or I think, as I mentioned, valuation disputes are the ones I've been involved with the most. And then you can probably have a little bit more comfort about having independent experts from each side being appointed, and some sort of process where you'll have an arbitrator who knows a bit more about it. That said, I'm sure commercial courts, are perfectly fine doing that. On the general contracting side, I think you've alluded to before, when you have multiple parties in different countries, even on a supply chain, you would pick LCA or Singapore, and I think that is quite common. I think everyone probably assumes it is not a cost saving. Maybe it's even more expensive potentially in the courts. Now, I know that was touted as an advantage a long time ago, but I don't think that's necessarily the case anymore. But confidentiality is probably one of the biggest things now. So just keeping it private, because often we'll do those deals, we will have a big fight with the other counterparty, but we have to keep on working with them. And if that's all in the public and all being aired, that is certainly, in a court, that is certainly going to destroy relationships. So that probably is one of the other factors we're putting in terms of why we choose it more.
George, how about you?
Yeah, I mean, we universally have arbitration agreements in all our contracts, which, as I mentioned before, obviously tends to be the way with construction projects, with international contractors. But, to give a more specific answer, the privacy considerations, but also, keeping... I think particularly international contractors have a hesitancy, and an understandable hesitancy, to go before the court of counterparties, home nation. And then I think, as has come up time and again during the sessions today, that whereas cost and time aren't necessarily advantages of arbitration anymore, flexibility remains so, and having the parties have the freedom to be the architects of how they want a dispute resolved. Sometimes it might be a really narrow issue which you just want to get a single arbitrator to decide, and then you can reach a settlement or whatever. Is not. It's got better in the courts, but obviously it's a traditional strength of arbitration, and it remains so.
Catherine, maybe you could give us some of your thoughts on that.
I think for us the main attraction is going to have to be flexibility. Like I said, we've got a client base across various jurisdictions with various levels of rules and different types of transactions that we transact with clients across different jurisdictions. But generally, the principle itself is already embedded in the way that we operate. Like I said before, we deal quite a lot with exchanges, and they have their own rules, and so disputes arising from those particular transactions are already resolved in that way. With respect to general contracts, there is some appetite for arbitration, but I think the main reason for that would be flexibility. With respect to time, that used to be a significant factor, but as we've noted today, possibly not quite so much these days, but nonetheless, it's still something that features in the decision-making with respect to what particular tool we use.
And Ava, maybe you could finish.
Yeah, well, tendency in our business is to move away from arbitration. We are tying contracts mostly to the place of business and looking for mediation as a solution. The reason why is because this market isn't that big, and working with clients, usually work with same clients for a long time. Therefore, it's not comparable maybe to other businesses when you have some business across many jurisdictions, when I would see then arbitration as a good solution. But for our business, no.
Okay, thank you. Tom, do we have any questions for the panel from the audience?
We do indeed. The first question, what metrics are the panel using to ensure diverse teams are used in their matters? And what penalties are you prepared to put in place for firms that do not?
Does anyone want to field that one?
I think that generally the procurement isn't performed by me within SSE. We have our own procurement team, but I know they take it extremely seriously. The big long forms that anyone who wants to contract with SSE have to go through, and a big part of that is our diversity, not warranties, but representations about the steps that they are making. It is rightly a big issue, I think, for most clients, and I think that there's still a lot of improvement which can be done, but hopefully that those steps are beginning to address some of the historical issues that we've faced.
Anyone else on that one? No?
We probably all have very similar standards about the procurement here. So I guess, your answer covers.
Yeah.
Yeah.
ESG generally is fund space, we've got criteria rated on that, so we will therefore have to rate our suppliers in a similar way. So it flows through.
Sure. Have the panel used litigation funders? If not, what are the barriers that are stopping you?
Not personally.
No.
Nope.
No.
Any thoughts on the barriers? Or?
It's an interesting perspective about, I guess it's just balance sheet management, isn't it, really? I've certainly been in proceedings against us, funded by litigation funders, which has been interesting, and we've just tried to convince them that there's a bad return on investment, and they decided not to go ahead. So, which is probably an interesting level of objectivity that perhaps the party who feels aggrieved doesn't have. I guess if it was a big litigation and we didn't want to take all that balance sheet risk, we could consider it. I don't know how people feel about it.
Yeah, I agree. I think it's a balance sheet calculation, and it's never not really something that we've had to consider. But I'm not even sure it's something that we would necessarily consider in the future unless it was pressing circumstances for it.
And as perhaps one final question, we previously heard about the risk of losing confidentiality in arbitration on appeal in London. So do you look at safer seats with anonymity options such as Scotland?
I think that's confidentiality is important, but also
who wants that one?
when you choose arbitration, you're not just thinking about confidentiality. You think about the particular subject matter. You think about the place of performance. So there's so many other factors that I think perhaps that particular point might rank somewhat lower in totem pole, because ultimately you want it resolved. Yes, you have to think about worst case scenarios, but I don't know that that particular factor would trump the place of performance and the particular subject matter, really. I don't know what anyone else thinks, but...
I mean, in some businesses I was working before Spectra, we would choose arbitration place because of a location more than the question on, we kind of, I mean, there is, maybe it's not good to say like that, but it's like more like a general trust that it should not happen, notwithstanding where.
Brilliant. Well, those are all our questions, so please join me in thanking our final panel of the day. And just before you shoot off, I would like to offer some closing remarks. First of all, I just wanted to echo what Jonathan said this morning and how much of a genuine pleasure it's been to actually see people face to face again after so many years. I hope that you've all enjoyed that experience as well. I think people have enjoyed themselves and taken some value from the day, both online and in person, so that's great. I also just want to issue a few thank yous very, very briefly. Firstly, to our sponsors, because obviously without them, this wouldn't be able to take place. To my colleagues at Legal Business, In-House Lawyer, GC Magazine, and Legal 500 for organising this event and helping to run it. Likewise to the staff at the QE2 today, who have all looked after us really well. I'd like to thank our speakers, both in this current session and throughout the day, for giving up their time to offer us some insights. I'd also just quickly like to flag next month we have our Commercial Litigation Summit on the 8th of November. That'll be held near St Paul's, so please pass that on to your litigation colleagues and see if they would like to attend. But as I realise I'm the only person standing between you all and some booze, I would like to open you up to some drinks and canapes downstairs. Thank you very much.